Welcome, everyone. Just letting folks in right now from the waiting room. Um, give us just a second. This is our webinar. Topic today is co-parenting and relocation in Washington State, legal considerations and strategies. So welcome to the webinar today. In just a moment, I'm going to be joined by Michelle Dellino from Dellino Family Law Group, and she's going to be delivering a lot of great information on this topic and also taking some of your questions. Quickly, I'll introduce myself. My name is Melissa Rosenberg, and I'm a therapist here in Seattle. And I work with clients who are at different stages of divorce and separation processes or who are navigating family law challenges and dealing with the emotional ramifications of all of that. So yeah, I really love supporting people on the emotional end through these processes and helping folks to feel supported as they navigate. Um, I work with both individuals and couples, and it's a big part of the work that I do. Today, I am here as a moderator for this webinar. And so what we're going to do, I'm going to turn it over to Michelle in just a moment to introduce herself, and then she's going to deliver information specific to this topic today. And we do also have monthly foundational series as well, where it's more general family law information being delivered. But today is specific to the co-parenting and relocation in Washington State topic. So if you have questions along the way, as Michelle's talking, please go ahead and ask those via a couple of different options. We can do the chat, and if you send questions to the chat, they will come just directly to me. I'm setting it up so the attendees can just chat with me. So if you send a question through the chat, I'll get that and I can pose it to Michelle and we can try to see if we can get it answered. The other option is to send it to the Q&A option at the bottom of the Zoom screen. You can select yourself to be an anonymous attendee. Otherwise, your actual name will show up with your question. Either way, you can send us questions and we can try to get them answered. One other thing is that if you do ask questions today, we can answer more general questions. If they're really specific and kind of deep into the weeds of your specific situation, they're going to be hard to answer. But if they're more general, please feel free to ask them and we will do what we can to get those answered. So thanks for being here. We will hope to leave you with a lot more information than you came with. So with that, I will turn it over to Michelle.
Hi, I'm Michelle. Thanks for being here. I am a divorce and family law attorney. I'm the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we help clients all over Washington State. I've been practicing family law for 16 years, and what that means is probably you're crazy is kind of my normal. So we deal with family law issues of all kinds, whether it's relocation, divorce, legal separation, parenting plan modifications, child support, you name it, and we deal with it. So today we're going to talk about relocation. And before we get started, I'm going to tell you a couple of things. One is that I am an attorney, but I'm not your attorney, and this is not legal advice. So I'm here to give you as much information as I can. I might give you my opinion on things, but it's just an opinion. It's not legal advice. The only way you're going to get legal advice is to have an attorney-client relationship with someone. So you could do that with any attorney, but you actually need an attorney-client relationship to get legal advice. So just want to put that out there for you. So think of this as information. Feel free to ask questions that are on point with relocation, co-parenting and relocation situations, long distance parenting plans, all of that good stuff. I'm here to try to help as much as I can. But like Melissa said, if your question is really fact specific and it's really getting into the details, I might either have to generalize it to get you an answer, or we might not be able to get to it. So I hope that helps. If you have other questions that aren't about relocation, you could come to our foundation series or our meetup group that we'll talk about at the end. So with that said, I'm going to talk about Washington's Relocation Act. So what is it? What are we even talking about? We're talking about a parent relocating, and we'll talk about where in a minute, but relocating with a child. And I think the most important thing I like to tell people right off the bat is the court can't stop you from moving. The court can't say you can't relocate, you can't move. What the court can say is you can't do that with the child. So that's really, really important. A lot of people want to say, well, who's the court to tell me if I can move or not? Well, they can't, but they can tell you if you can relocate with that child. So, all right, we are talking about, some people like more information than less, but don't feel like you need to write these things down or anything like that. Also, this webinar will be posted on our YouTube channel, so you can watch it again if you'd like to. But Washington's Relocation Act is RCW 2609-405 through 560. So that is the statutory framework that deals with Washington's Relocation Act. Do you need to look at that? Probably not. But some people like to, so they want to know that. Who does it apply to? It applies to parents that have residential time under a parenting plan. So what that means is if you have a parenting plan in Washington, there is going to be a spot in there where it lists the relocation statute and it gives you information about the notice provision and what you have to do. That's in every parenting plan. Whether it's a temporary plan or a final plan, it's going to be in there. So that's important for you to know. It pertains to you if you are a parent and you have a parenting plan in place. If you don't have a parenting plan in place, you're not bound by the act, but that doesn't mean you shouldn't know about it and be thinking about things as you move forward. So the basics to know: notice requirement. Notice to the other parent. This is what's in parenting plans, and this is the most important part. I believe this is RCW 2609440. You are required to give the other parent 60 days notice before your intended relocation. And when you do that, it needs to include a new proposed address, phone number, school, and reasons for the move. So here's the thing to know. Before we even get there, I want to talk about where the move is and who it pertains to. If you, let's just say, for example, are living in a certain school district and your child is going to school there and you have more than 45% of the residential time, you have to give this notice, okay? And if you are moving, you have to be moving outside of the school district. So it's important to know that relocation doesn't just mean out of state. Relocation could mean I'm moving from the Seattle School District to Bellevue. Relocation could mean I'm moving from Bellevue to Boston. I'm moving from Seattle to Yakima. It can be a far relocation or it can literally be across 520. I've dealt with both, and you still have to give notice. It's interesting because think about it. I don't know how well you know your geography, but if you were living on the east side and maybe you were living in the Lake Washington School District and you lived in Kirkland, if you went like right up the hill, maybe like not even a mile or two, you could be in the North Shore School District and be very, very close, right? So that's super close. It's not about distance, it's about the school boundary. Okay, so that's important for you to know. And you're required to give that 60-day notice if you are moving outside of the current school district and you have more than 45% of the time. There are some exceptions to that 60-day notice. And I like to start talking about the notice because that's kind of the meat and potatoes for a lot of people. When do I have to tell somebody? Okay. And there's a short notice exception. If 60 days is impossible, you have to give notice within 5 days worth of knowing. So like, when would that come up? That would come up if you got notice that you had to transfer and move for your job within 30 days. If you got military orders, if there was a really, if, you know, like a family member, like your parent or something got sick and there was no one else to care for them and you needed to go because they're dying or something. So really extreme situations or really situations where you couldn't have known, you have 5 days from the time you get the notice to give the notice to the other party. Otherwise, you got to give 60 days. The tricky part of this too is you have to give an address, and most people don't have one because they don't know even if they're moving yet. So you can, there's ways that you can, you know, be clear about that in the notice. The notice is incredibly important. I can't stress to you enough that you should get help with the notice because you have to give the reasons for the move. And then we get into talking about the statute, and there are a number of factors that the court will evaluate, and claiming what those are in your notice are important. Like just claiming what they are, being clear about your intent is really important. So once you've given that notice, what happens next? Well, the other parent has rights. They must object within 30 days of service of the notice. If they don't, it's assumed that you can move. And when their objection is filed, they file it as a petition under the existing case number. So it actually starts a new action. It starts a relocation action. You don't actually start an action when you give the notice. You're just giving a notice. They might not object. Nothing might happen. You might just move. That could totally happen. But if they object, they actually have to start a new case and it goes from there. If no objection is filed, the relocation is permitted by default, unless for some reason it's contrary to the child's best interest, but you can move if they don't object, basically. So once somebody objects, the court can then enter temporary orders either restricting the move, so restraining the relocation temporarily, or permitting the move pending a final decision. And that's where we get into a lot of other specifics and why it's important to claim why you're moving and be really clear about that, and so on and so forth. You'll have, here's the other thing to know. There is a presumption. This is kind of the burden of proof portion of this. There's a presumption that that relocation is going to be permitted. Now, the specifics of your situation are going to really dictate how likely that presumption is. If you're in a parenting plan and the other parent is an every other weekend schedule, there's a strong presumption you're going to get to move if there's a good faith reason. Okay. There's a presumption you get to move. There is anyway, but if you're in a plan where maybe it's a 60-40 plan where you have them 60% of the time, the other parent has them a lot, right? Then it's really not, as I would say, cut and dry, and it's going to come down a lot more to the reasons and different things you want to know. But anyway, there is a presumption that the relocation will be permitted. The burden is on the objecting parent. The objecting parent must show that the detriment effect of the relocation outweighs the benefit to the child and the relocating parent. So that's kind of confusing, but it has to show that that benefit is outweighed by the detriment that'll happen to the child. Because keep in mind, parenting plans in Washington are always under the best interest of the child. It's not about what's best for the parent. So it's always going to be what's in the best interest of the child. That's central to this. So we're even looking at that when we're thinking about the effect of the relocation. Does the detriment effect of the relocation outweigh the benefit to the child and the relocating parent? Important distinction is that there's a strong presumption in favor of relocation unless the other person does a good job rebutting it. So that's important for you to know. There's 11 factors. I mentioned this earlier. There's 11 factors that the court's going to consider, and no single factor is dispositive. So there's a number of factors, and you're going to want to like address these when you are looking to relocate or if you are objecting to the relocation, because objecting is also just as important. You have to have really good reasons, and you need to develop the factors in the paperwork for the court in why you're going or why it should be restrained. So I can go through the 11 factors. Melissa, do you want me to take any quick questions before I do?
I have one question. They're asking if you can actually put it into the parenting plan that the primary parent has the right to move out of state or country with the child.
No.
No. Yeah.
You cannot. Many times people will do that. I mean, you can put anything in the parenting plan that you want. It doesn't mean it's going to be valid. You can't waive the statute.
That's a good question.
Prior agreements are one factor. So they are like prior agreements of the parties are one factor. It's a factor that will be considered if you guys have an agreement, but it's not dispositive. It doesn't mean you can waive the statute, because again, it's about what's best at the time. So yeah.
Okay.
Anyway,
Thank you.
Yeah, everybody asks that. So I'm going to go through the 11 factors, and some of them are confusing, some of them are straightforward. The first one is the relative strength. I think it's strength, nature, quality, extent of involvement, and stability of the child's relationship with each parent, siblings, and other significant persons. And just so you know, the statutory factors are set out in RCW 2609520. People will talk about subsection 520 the most. It enumerates all 11 factors. You could also just Google it, and there's probably a lot of pages that will tell you the 11 factors as well. So the first one, I like to talk a little bit about them so you kind of understand. The first one's about the strength, nature, quality, extent of involvement, and stability of the child's relationship with everybody. So that means like if your child is really, really tied into the community, they've got a lot of family here, they've got a lot of close ties, they've got maybe half siblings that they would be separated from, all those things matter. So it's all about the quality of the relationships, what their involvement is, the relationships with the parent. If the other parent has a bunch of time with them and they're super involved in their stuff, that's a factor to consider. Or if they don't, that's a factor to consider. The second one is prior agreement of the parties. Like I said, if there's well-documented prior agreement, that's one factor to consider, but it doesn't waive the statute. The next one is whether disrupting contact would be more detrimental than disrupting contact with the relocating parent. And this kind of goes to what I said at the top, which is the court can't stop you from moving. And if you have to move for a job, you got to move, right? So the court can't say you can't relocate, but the court can't say your child can't go. So the court's now basically saying, is disrupting contact between the parent that's moving, assuming the parent's moving, more detrimental than disrupting contact with the other parent? So, and that can be a hard thing to evaluate. The next one is whether either parent is subject to limitations under 2609191. I don't know if anyone's heard of 191 factors, but 191 are restrictions in a parenting plan for abuse, neglect, domestic violence. If you have 191 restrictions in your plan and you're the parent that's subject to those restrictions and the other parent's trying to relocate, that's usually something that's in favor of the parent who's trying to relocate, because you already probably either don't have decision making or you have less time because you have 191s. So that's something to keep in mind. The reason the parent has for seeking or opposing relocation. So if you're moving, for example, and you're doing it because you're like, oh, I started dating somebody new and I want to live where they live, that's not going to be a great reason for the court. If it's like, oh, my company is requiring us to be in office and it's located somewhere else and I have to be there to keep my job, that is a good reason. Or if it's I was only here for a limited period of time and my entire family and support network is there, that's a pretty good reason too. The reasons for objecting are also equally as important. So that's something that needs to be considered. Um, the next one is sort of an obvious one, but it's something that people don't even think about the way they should. This one is the age, developmental stage, and the needs of the child, and the likely impact of relocation. So if this is like a baby, they're not like being taken out of school, they're not, in that kind of a situation. If it's a school age child, what's the age that this child is at? Is this child being asked to move in the middle of like their high school? Because that's probably going to be really hard. Is this a child that's in elementary where a move might not be as disruptive? Those kinds of things. What's the developmental situation as well when it comes to the child? Quality of life. The next one is quality of life, resources, and opportunities in current versus proposed location. I actually hate this one. It's my least favorite one because it always results in clients being like, hey, here's a chart about why moving to Southern California or wherever the heck they want to move, or here's a chart showing why Bellevue schools are so much better than Seattle. There's so much better opportunity. Well, keep in mind that no judge is going to say that it's crappy here. Like they're from here, they're civil servants to this community, their kids probably went to school here. So if you're like the schools here are so bad, and their kids probably went to public schools, by the way. So if you're like the schools are so bad and I can move to this other area and it's so much better and Seattle's a piece of crap, that's probably not going to get you very far. So, there's not a lot of opportunities since we live in a major metropolitan area that you're going to be able to say are unique to somewhere else. That being said, if, for example, the other parent wants to move to somewhere where there's not a lot of opportunities, and maybe you have a child that has special needs or is really involved in a lot of things here, and those opportunities don't exist there, it might make a difference. But don't go in with the data from the school district showing why the current school district's a piece of crap and the one you want to move to is so much better in Bellevue. Don't do that. Like, it won't get you anywhere. It'll probably get you like slapped on the wrist. So anyway, that factor, you really need to think about how you present it. The next factor is the availability of alternative arrangements to maintain the relationship with the non-moving party. So, for example, you might have a parent that I've had a lot of relocation cases over the years, and sometimes there'll be a parent that can travel to the area easily. They have the resources. We're just talking about a move to the Bay Area. They can get down there pretty easily. They might go down there for work. So things like that. Or there's the question of like, can they move there? And that's another factor we'll get to in a minute. The last factors are alternatives to relocation available to the relocating parent. Sometimes there aren't any. Sometimes like you have to move, you have to move. Other times there's plenty of alternatives. The next one is the financial impact on the logistics on the relocation. Like, is it financially better for someone to move somewhere else? Does it make it more attainable for them? Is the cost of the transportation between the two places going to be difficult? Like, what are the financial, ramifications? The last one is whether it's feasible for the other parent to relocate also. And that might sound kind of crazy, but it's not always. Like, you might have sometimes two parents that work for Amazon and one parent's moving. Can the other person also move and change their job? Maybe. Probably not, but maybe. So there's a lot of different ways to look at that. Or if one parent doesn't work or is self-employed, can they move? Probably. But how expensive is it there? What's the situation? Who owns a home? A lot goes into all these factors. That's a very brief run through. I just like to talk about them so you understand more than just remembering them and writing them down. There's a lot. So you need to realize there's a lot. And there's a lot of things to consider and think about. In a relocation, if nobody objects, great. But a lot of the time someone does object. And even if you have the presumption, you still need to know, why am I doing this? What is my case? What does that look like? And how do I prepare for that? So anyway, I hope that helps. I can talk about more, but before I do, I'm sure there's probably a couple questions.
Yep, I got a few here. Somebody's asking, if I relocate to a different address but remain within the same school district as the other party, am I required to file any notification or paperwork with the court?
No. not under the relocation statute. If you probably have it in your parenting plan, Section 14 has all the extra provisions. It'll very often stay in your parenting plan. Both parents are required to keep the other parent apprised of their current address. You should tell the other parent I'm moving, but you don't need to like give an actual relocation notice if you're staying in the same district.
Great. And what if the child is not of school age yet? How does that factor into the objection potentially?
Well, here's the question, like, you still have to give, you're still moving with the child. So it doesn't matter if they're not in school. But the question is, because when children aren't school aged, and we'll get to this in a minute, the kind of long distance plan you might have might be different. And so the objection still needs to be made, but what you're proposing or what it could look like would be different. And is this a child that's going to be school age next year? Is this an infant who still has a few years? It kind of depends, because long distance plans that don't have school constraints can still mean that a child who's not school aged can have more time with one parent than if, you're really constrained by the school calendar. So how you want to frame the objection and what the objection looks like might be a little bit different and more fact specific.
Okay. You kind of touched on this one when talking about the factors, but this person's asking, what if you have a 50% plan and you have to move because of losing your job in the current state? The other party doesn't have a job, and if you stayed, then nobody would have any income. Is it then possible to kind of move to a new state with the child?
Well, if you're on a 50-50, probably not. I mean,
Mhm.
you still need to, it's going to require, here's the thing, a relocation is a modification of your parenting plan. And you're going to have to modify your parenting plan. Whether you're relocating with the child or not, if you have to move, you got to move, right? Like I said, the court can't keep you here. But, and we'll get into this when we talk about long distance plans. The parenting plan is going to have to look different no matter what. And when I say you're probably not going to get a relocation on a 50-50, you're probably not, because assuming that your child is school aged, is already like in a community and has, and still has a lot of time with the other parent. So a 50-50 is it's a really, really tough situation, and you're not necessarily dealing with the same set of facts that you would be. So it's tough, and that's a really tough situation. But you're right, like if one person has to move and they won't have income otherwise, then it's going to be like, well, can you get another job? What are the alternatives? And then you go to looking at those factors. So anyway, a number of things there. Okay,
Mhm.
anything else?
There is one more question here. How does one go about removing 191 restrictions? The context is, they're saying that their ex lied about them in court on the last day and that evidence was ignored. They were pro se and they kind of got screwed. So how do you go
Yeah,
about getting?
you're not removing 191 restrictions. That's not going to happen.
Mhm.
I don't want to give you a hope that that's realistic. And I'm not saying that like you should have them or that everything went great, because sure, things happen, but your opportunity to challenge restrictions was a trial, or to not agree to it in mediation, or if you felt that something happened, you had a right to an appeal. And if you didn't do that and you have 191s, you're not going to be like removing those. There should be conditions in your parenting plan like that you have to meet. If you've met those conditions, maybe you can change the residential time, but getting rid of restrictions isn't something that's going to happen. So I don't want to have you think that. It doesn't necessarily mean either that if you are subject to 191s, you could have 191s and have a lot of parenting time. And if you have 191s and you got 40 or 50% of the parenting time, it's still going to be really hard for the other parent to move. It doesn't mean that like they automatically get to move because you have 191s. But if you have 191s in a final plan, that's usually a pretty final thing. So just so you know. Okay. So some things to know, and this is really, really important. Notice is everything. If a parent fails to properly give notice, relocation can be denied. It probably will be denied. It also too is if you move and don't give that notice, you could be ordered back. And I've seen that happen too. You could have to come back. Like I had a client once where the other party didn't object and just went to Florida. Guess what? The other party had to come back, even though they had already taken their kids there and school had just started. They had to come back because they didn't give notice, and then they didn't get the relocation. So you have to give notice. You really, I led with this too. You really need to frame your arguments around the statutory factors because the court judges, they're required to go through them. And these are judges' motions. Like a judge is going to hear your relocation trial, not a court commissioner. The hearing that deals with whether to temporarily approve the relocation or restrain the relocation is going to be before your trial judge. And they're required to go through these factors. So the arguments and your everything else needs to be framed around the factors. The evidence really matters. Like a lot of people, I made light about making the school comparisons issue. A lot of people will do that. It doesn't usually get very far, but other things do. Like things like family and community ties, parenting history, job opportunities, those facts really matter. Sometimes, not always, there might be expert testimony on a child's developmental needs, or there might be a guardian ad litem or a parenting evaluator who gets appointed during a relocation case. But that will really have to be on an expedited schedule because relocation cases are on a quicker, basically time to trial because there's a sense of urgency as opposed to a divorce. Temporary orders can really shape the status quo. So it's important to know like a temporary relocation is not going to be granted under the law unless it's likely that the court believes a final relocation will be granted. Does that mean it's final? No. But does that mean it's a really strong factor? Yes. If the relocation's denied, does that mean it's going to be denied at the final trial? Not necessarily, but it's a pretty strong, it's a strong factor, the status quo. Mediation and settlement. So mediation is required under the case schedule. And I've mediated a lot of relocation cases and a lot of people, and relocation cases are one where it's like, it's either going to settle or it's not. You're either going to agree that the other party's going to move or they're not. So a lot of people think, well, what's the point of mediation? I'll tell you what, I've had some really successful mediations in relocations because that's your chance to really hammer out what does the schedule look like? What does the plan look like? What are the things that I can negotiate for and get here that I probably wouldn't get like when a court's making a parenting plan in a trial, right? Because they don't have to go with what you propose or what the other side proposes. So, there can be a lot more liberal negotiation in a mediation, and it might not be the best situation, but it might be something that you can live with that's better than might happen in court. So either way, I've also had a lot of relocation mediations where it's like, hey, we're here, we tried, it's not happening, and now we're going to trial. Because it is one of those things, you're either moving or you're not. So think about this. These are like some key takeaways I'm going to talk about before I start talking about long distance plans. Relocation Act. There's a presumption in favor of the moving parent. It can be rebutted. The objecting parent has a heavy burden and they have to object timely and file a case. They have to demonstrate that the detriment outweighs the benefit. The court's going to weigh all 11 factors. So these are fact-driven. It's a highly discretionary analysis, which means the court can basically think and do whatever it wants. But what you present is really, really important. There is a strong I think of these as like policy arguments, a strong policy in supporting stability with the primary parent, unless there's a real reason not to. So, and again, that goes to the presumption. So hopefully that's helpful. I mean, when parents live far apart, different cities, states, or even, Tacoma to Everett it could take a really long time. Plans look a lot different from really local arrangements. So Washington law doesn't give an exact schedule for long distance parenting, but there's common models that we see and kind of use. So the idea is to preserve meaningful contact with both parents while recognizing that, a lot of frequent short visits just really isn't practical in a number of ways. So I can talk about that more unless there's anything else, Melissa, you want me to address.
Yeah, we have a handful of questions. Okay, so for a shorter distance, like less than 8 miles with 50-50 plan, is housing affordability a good reason for relocation?
I mean, I'm going to ask this if it, you don't have to answer this now, but just think about this. If we're talking
Yeah.
8 miles and you're moving for more affordable housing, cool. But why is the other parent going to object to that? Like, is it really are those 8 miles really going to force you is that really a reason to object? Are they objecting because they don't like the change in the school district? I mean, that could be an issue, then you got to think about is it really more important for you to change your child's school district, or is the other parent in the district? You can just switch the address. 8 miles is not,
I think it's more like they're saying he just doesn't want to have to drive 8 miles to the house.
yeah, that's probably not going to be a good reason. It's
Yeah.
different if those 8 miles are like, I had a case once that was like Greenwood to Deep Bellevue, and the court actually did not approve that relocation to Bellevue. So
Mhm.
because they didn't like the thought of And the other parent was like, I'll bring them back to go to Seattle schools in the morning, no big deal. And the court was like, well, that's the kids having to sit in the car every hour, for over an hour in the morning in that kind of traffic and whatever. And the court denied the relocation. So it depends on where those 8 miles are, what that looks like. But yeah, reasons are reasons, and you have to look at all of the reasons. So anyway.
Mhm. And speaking of reasons, this other person is asking, so if you are 50-50 and the other person wants to move to another country just because they don't like it here due to political issues, etc., is that very, is that I don't know, what would they have to do in order to make that probable? Like,
They probably have to
is
go
that
by
a good enough
themselves.
reason?
They probably have to go
Yeah,
by themselves. So I don't, yeah, they probably have to go alone. So
not
yeah,
it's not a good enough reason.
no. Mm-mm.
Yeah, yeah.
Yeah.
Okay. And let's see, another participant is asking, if you have to move because of work and the court does not allow the child to be relocated, what happens with the child? Does that mean they stay with the relocating parent 100% of the time? Then
Yeah,
you
it
have to
means it
pursue a new
means you're the
parenting
long
plan?
distance. It means you're the long distance parent.
Yeah.
So basically, and a lot of times, I will tell you this, a lot of the time when somebody isn't going to move, they'll basically withdraw the relocation if they think it's not going to happen. And they won't go. Other parents, though, like they have to go, right? So they got to
Mhm,
take it all away because they have to go. They have no choice. And what happened then, either way, a new parenting plan is going to enter. And you would
mhm,
be the parent who has the more liberal vacation visitation and the other visitation. And I can talk about that in a minute. But yeah, there would be a new parenting plan. It would just have the other parent be primary. So
mhm,
yeah.
mhm,
I mean, the general principles really are stability. So the child usually resides primarily with one parent during the school year in a relocation, like in a long distance plan. Extended blocks, like these are the general kind of principles to know. The other parent gets longer periods, like weeks at a time during school breaks. They get way more of the summer. They get more of the holiday breaks. Sometimes like if it's like Seattle to Portland or I don't know, Seattle Bay Area, and the other parent has the resources, they might get like all the 3-day weekends, something like that, right? They might get midwinter and spring break, right? They're going to get more of the summer because you have most of the other time. Fewer transitions, so to minimize stress, plans to avoid frequent long distance travel are favored too. Like you're not going to have your kid like on a plane every other weekend. That's just not going to happen. Even if you can afford it, it's not good for your child. Shared costs, so parenting plans and child support orders will address things like a parenting plan will address the transportation arrangements and where exchanges are going to take place, what that's going to be like. And the support order will deal with the allocation of costs for long distance transportation because typically both parents will share in that cost. Common structures, if you have school age children, like I said, they'll usually reside with one parent during the school year. Non-school non-school parent time. Most of the summer, alternating major holidays, like they're not going to get every Thanksgiving. You're still going to get some of those.
mhm,
The winter break, spring break, all of those are going to, alternate, but the other ones are not. The other parent's going to get most of those. So that's something to know. Yeah. Virtual
mhm,
contact in long distance plans, regular phone calls, FaceTime, Zoom, whatever. For younger kids who are preschool age, more frequent visits may be possible since school isn't a factor. Different parenting time splits, still visits are often scheduled in chunks of time because developmentally it's hard to have, a child going back and forth that much, and travel like for a really young child just isn't always practical. But you might be able to do something different if you're not constrained by the school schedule. So also too, if you have teenagers, that's even more different because one parent might be like, hey, I want my 16-year-old for the entire summer, but the 16-year-old probably has extracurriculars, social connections. They might have a job, they might have things they're heavily involved in, and that will be taken into consideration. So the travel blocks might be shorter but more frequent, and the teen can also fly unaccompanied and manage travel more independently. So there is
mhm,
that kind of thing to keep in place. So long distance schedules can really vary. Parenting plans often allocate airfare costs, shared equally or proportional to income on the child support worksheets. So provisions about who travels with the child for younger kids and airport handoffs are really, and where that's going to take place are really common. Many plans explicitly require cooperation in booking travel early to minimize cost. We'll say parent A who's proposing the travel has to book travel 21 days in advance because you guys are sharing in the cost. And we don't want like these last minute expensive tickets, things like that. Um, Special considerations for you to know as well is that in Washington, courts really emphasize maintaining strong bonds with both parents despite the geography. So don't think that you're just going to move and the other parent is like never going to see the kids. That's not going to happen. They are going to get more vacation time. They are going to get time. It's just going to look different, or if you're the one that, the child's moving and you're staying, you're still going to get that time. It's just going to look different. So the bottom line is that long distance parenting plans typically consolidate non-residential parents' time into longer, less frequent blocks, especially like summers and holidays, with frequent virtual contact and really clear transportation arrangements. So that's kind of what to expect if there is a relocation. The process for relocation is what we talked about earlier, giving notice, objection. There may be a hearing on a temporary decision on the move, or there might not be. There might be a trial. There'll be a mediation before there's a trial. So there's a lot of things, and it all centers around those 11 factors. So you really need to prepare accordingly. So any other questions?
There's a general question that just asks what is required to initiate mediation. So I'm
Well,
not sure.
yeah, I mean, that's a good question. One thing I would say is this. So mediation is going to be required under the case schedule if somebody is objecting to a relocation. To initiate it, I mean, if you're going through a relocation, you really should have an attorney. You aren't going to understand the law and how to argue it. Even non-family law attorneys, they don't understand. Once in a while, we'll have somebody who has like a non-family law attorney trying to do this, and like honestly, that's, to me, it's borderline malpractice. Just as though I would never go and try to help a client in like an employment law dispute. Like I could probably understand what they were saying, but that's not my deal. I would make mistakes. I would never do that. And an attorney who doesn't practice family law should not handle a relocation. Even a very new attorney should not handle a relocation. So anyway, if you're trying to do it on your own, at least get some guidance and help. But mediation in a relocation, it should be very strategic as to when you're doing it, at what point in the process, what mediator you're using, who might be best to handle the parties in this case. And you should really defer to your attorney on that. The way it's usually initiated is one person reaches out to the mediators that they've agreed upon using. You need to agree on mediators too. And they check availability. And like I mentioned earlier, a relocation is on a case schedule that's an expedited schedule compared to a modification or a divorce. So it's going to be a more expedited timeline. And it's also going to need to take into consideration if there's been a guardian ad litem or a parenting evaluator appointed. And sometimes there is to help give an opinion on the relocation. If so, you can't do mediation until you have the report. So that's another thing to keep in mind. So anyway, it's nuanced, but mediation is a really important and required part of the process. So.
Another question, this person is talking about, it sounds like there's been kind of an equitable transportation situation where they've been driving 4 hours a day for 2.5 years, sorry,
Oh my
to pick
gosh.
up drop off their son. And the mom just lets the son walk to the end of the driveway to get on and off the bus. Is there a way to, I don't know, make shifts there or deal with the inequitable driving time?
Well, I guess the question would be, you might be talking more about a parenting plan modification, like if there's not a
Yeah.
move right now. If you're looking at a modification, you need to have a substantial change in circumstances that didn't exist or couldn't have been contemplated at the time the last plan entered. If something changed about the driving or the situation, when you agreed to it and it's changed now, you could seek to change the transportation provision, but you have to have adequate cause to do so. So that's a
Oh,
modification.
okay. It sounds like they're actually saying there's no court has been initiated. It's just what they've been doing. This is
Oh,
just what they've
if
been
you don't
doing.
have a parenting plan, then stop doing it. Like, I don't
Yeah.
know. And get a parenting plan
Get a
that says,
parenting plan.
yeah, and stop
Yeah.
doing it. You don't have to do it. So,
Yeah.
yeah, I know
Yeah.
that's easier said than done sometimes because then it's like, what's going to happen? But yeah, make the other parent be a little more equitable in sharing the burden. Because I mean, we all know that traffic in this area is terrible. It's only getting worse. It's not really getting better, especially with I-5 closed lately. But you need something that's equitable and practical. And it's important. I'm glad you brought this up because this is something not just in relocation, but in parenting plans in general. The transportation provision, who is responsible for transportation? The dropping up parent or the picking up parent? Where are the exchanges going to take place? All that kind of stuff is really important in your plan and to have clarity surrounding it. So great
hmm
question.
hmm
Yeah.
Another person's asking, can you please restate the process for providing notice if you don't yet have an address?
You still have to provide the same notice. You could just
Hmm.
provide details on when you expect to have that address. Or if you can provide the address of like if you have like your parents live there and you're going to be staying with them, you could say living with parents at this address while we look. It depends on the factors. Like there's different things that you can say or currently looking, for, uh, housing in this area and date will update when you have it. But you can say you'll update when you have it, but you need to give some specifics and you still need to give notice, even if you don't have an address.
Okay.
Most people don't, honestly. A lot of people don't because they don't know and they've just started looking and they've just found out they got to give notice. And, other people have planned way ahead and they've already, whatever. But also if you're thinking that you might not relocate if you don't get it approved, or if the other party doesn't agree, you probably haven't bought a house or rented an apartment. So you might be staying somewhere temporarily. So you might give that address. There's a lot of different things you can
Mhm.
do. So,
Mhm. Okay. That's
yeah.
good for now.
Good. Well, I don't have anything else to share with you. I've shared the factors with you. I've shared kind of what the process looks like, and I've shared what long distance parenting plans look like. So, what I suggest that you do if you are contemplating a relocation is talk with an attorney. It does not have to be me, it can be anybody, but talk with a family law attorney that has handled relocations before, that understands how to frame these issues for the court. As you do your own research and look into it, I can't stress to you enough how important the 11 factors are. Every argument should be framed around the 11 factors because the court is required to look at those. They don't get to ignore them even if they want to. So I hope this has been helpful. A few parting thoughts. This will be available on our YouTube channel. I believe we've done one on relocation before, but it's probably been a while, so there may already be one there. I highly recommend that you speak with an attorney if you're contemplating relocation. Do a consultation, talk about your situation. A lot of the time will tell you, if you're ahead of the game, things that you can do to better position yourself to get a relocation approved, things that you need to know, like about your own individual situation that are helpful or not helpful, and how to frame the situation and how to move forward. So it's a tough thing, but it's something that a lot of people encounter. And it's why Washington has a statutory process. So anyway, wish you the best. We also, as far as other resources go, we do have a regular foundation series that you can watch every month if you have general questions. We also have a meetup group that meets virtually, usually the last Wednesday of every month, and meets once a quarter in person. We have a meetup coming up next week. I want to say that's August 25th. Does that sound right, Melissa?
I do think so.
Yeah,
Yes.
that's Wednesday evening on Zoom. We also have an in-person one coming up in September. So anyway, you can sign up for that if you're interested and you want to ask more questions and you want to hear other people's questions. That's always a good thing to do. Otherwise, take care and thanks so much. Have a great day. Bye-bye.
Thanks, everyone. Actually, you know what? That meetup date that Michelle mentioned is Wednesday, August 27th. That's a Wednesday. It's usually the last Wednesday of the month. But the one, like she said, in September is scheduled mid-month on the 17th. So we hope to see you guys. Please do get in touch with Dellino Family Law Group if you're looking to have a consultation with an attorney. Feel free to reach out to me if you're interested in some counseling services. I will leave this contact slide up here for just a few moments longer. And yeah, join us next time. Thanks so much.